Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. Today we are talking about the Supreme Court case Dred Scott versus Sandford, and we have Dr. Beinberg with us. Dred Scott versus Sandford is a landmark Supreme Court case. Why is this case so important in Supreme Court history?
Right. So, in some ways, I think even more important in American political history, because less about the doctrine and more for sort of what its political implications are. So, to back up a little bit before that, obviously, during the 1850s, the divisions over slavery in the United States are becoming more and more hardened. So, you see probably the beginnings of this with the Compromise of 1850, which in some ways is an effort to forestall this, but in other ways exacerbates it. So, for example, the Fugitive Slave Act of 1850 effectively requires northern states to actively participate in the suppression of escaped slaves in a way that they had never had to do that before. And so Northerners begin to feel, ironically in some ways, both on a states' rights claim that they're getting pushed around by the federal government, but also that their own institutions are being turned against them. And at the same time, the South is becoming more and more committed to the sort of positive, good vision of slavery. So we've talked about in an earlier podcast, the sort of consensus of everybody is sort of saying slavery is an evil, how necessary the North and South disagree. That is sort of shifting. Yeah. So slavery in the 1850s is getting more and more polarized. And so their efforts to sort of deal with that, ramp down the conflict. But this, again, sort of backfires in some sense with Bleeding Kansas. And the fear increasingly becomes that slavery is going to become nationalized. And Dred Scott effectively ends up being application of that fear, the vindication of that fear. Because the Dred Scott case effectively holds that the Republican Party, for example, its effort to deal with slavery, which was to say slavery can continue to exist in a state where it exists, but we want to restore the Missouri Compromise type rule that we can, and more importantly, the Northwest Ordinance rule, that Congress can suppress its expansion. That's what they want to do. And James Buchanan sort of, how do I put this delicately? Seemingly, there's, I think, some merit to Abraham Lincoln's fear that the Buchanan administration is basically collaborating with the Supreme Court. And so Buchanan's running around saying, everybody, we just got to wait for the Supreme Court to tell us what to do, when he sort of knows what the Supreme Court is going to do. So the Dred Scott case, when it comes down, has effectively three major prongs. And the first two, I think, are the third one is con law nerdy, but the first two, I think, are sort of more politically important. The first is the case reaches out and holds that blacks can never be citizens, even free ones, under the United States. So they cannot be citizens of the United States. And that's important because one of the issues in the Dred Scott case is effectively Dred Scott had been a slave. He had been taken to free territory in the Northwest Territory and in free states, and then returned back to a slave state. And so he's suing for freedom in that slave state, arguing that his time in the North had basically freed him. And so the question ends up being sort of a complicated federal jurisdictional case. So in order for the court to even hear the case, he has to have U.S. citizenship. So that's issue number one. The second issue is, could Congress, if it wished, prohibit slavery in the territories? And the third is effectively, is somebody losing their due process rights if they're forbidden from taking their property, which slaves were at the time, under local law into a territory? And so those are the sort of the main issues. And the striking thing is that Justice Taney tries to basically maximally reach each of those issues. There's a case to be made that just is a very technical legal position. The sort of legally correct case is the really boring technical concurrence by Justice Nelson. And Justice Nelson says, we don't need to decide whether blacks can be citizens. We don't need to decide whether the Missouri Compromise can be constitutional or not. All we need to decide is, does this guy have standing? And he wants to make it really, really straightforward and say, no, because Missouri says he doesn't. We can't have Illinois law on citizenship dictating Missouri law, because conversely, we also don't want to have Missouri law dictating Illinois law, right? So he wants to take effectively the position that neither state's rulings on citizenship are binding on another state, right? So this would effectively just say, Missouri says he's not a citizen, so he doesn't have standing, case over, right? And there's evidence that that's actually what the original opinion was supposed to be. But Taney seemingly wants to settle the slavery issue. And so he reaches out and writes this very, very sweeping and really, really long, which is unfortunate because it's also really, really wrong in terms of its legal history in so many places, as we'll talk about. But Taney reaches out to this sweeping opinion that says, no, blacks were not and cannot ever be citizens of the United States, maybe of a state, but not of the United States. That Congress has no authority to regulate slavery anywhere other than the original Northwest territories. Basically, any territory that Congress had at the founding. So any new territory that's added, Congress cannot regulate slavery, and that there is a property right that is no longer simply local, but could also travel to a territory. So that basically the property right that you have in Alabama should also be honored in a territory. And so that's a due process argument. And so for the Republicans, for critics of slavery, this has effectively declared the Republican Party platform illegal, and in effect, particularly because of that last piece, has now threatened to completely nationalize slavery and make almost the entire country. If you're thinking through sort of what's the implication of this precedent, that's a very possible argument. While also holding that, the dissenters aren't saying slavery is inherently unconstitutional, but they're just saying if the North wants to not have slavery, they can suppress it. And free blacks can be, in fact, free black American citizens. And the Taney opinion is basically making that effectively impossible. So it effectively really radicalizes everybody and tries to settle something, but in a way that is, in some sense, so heinously wrong as a legal matter that it becomes increasingly clear to Northerners that the sort of conspiracy theory of almost a slaveholder's power, is in fact becoming true.
So looking at this then, the Dred Scott decision, what are some of the longer term consequences of this decision on American society and its role leading up to the Civil War?
Right. I mean, in some senses, the longer term implications on American society are fairly minimal, with the asterisk of the Civil War, because its most significant parts are clearly overturned by the 14th Amendment. And so to understand sort of why on that, I do want to detour briefly to the dissenting opinions, Justice McLean and Justice Curtis. Taney professes to be doing sort of original understanding constitutionalism. Again, that's the predominant method of interpretation for almost everybody at the time. And Taney's opinion is really long, but the short version is, he says, effectively, we think that blacks could not be citizens in the states at the time. And he says, basically, there's two pieces of evidence for that. One, there were laws that were racist. And two, and this is the really interesting one, he says he recognizes that the Declaration of Independence, which is sort of the frame that people would use to interpret the Constitution, he says explicitly, it doesn't say white people, right? He makes this concession because the people pointing text at him are saying it doesn't say, we the white people of in the United States in the Constitution, or all men are created equal, asterisk, except, right? And so he recognizes that. And he's getting hammered for it by the dissents, who are saying, look, under original meaning understanding of like what text is, it doesn't say white people. It doesn't say black people. It just says people. But so Taney says, effectively, if we interpreted it according to what the seemingly normal way to interpret this text is, that would make the founders either morons or hypocrites. Because there's no one in the South that would have basically signed off on a position that says that, for example, a freed black or somebody who could become a former slave could become a citizen. He says there's no way that would ever happen. But he recognizes he's actually reading against the text. But he's basically trying to say an original intent versus original meaning. We presume that they would have meant this, even though the evidence seems to suggest otherwise. And so the dissenters really nail him to the wall on this. Justice Curtis, for example, goes through a list of 5 states that he says, in fact, we have evidence that not only were free blacks American citizens or citizens of those states participating in the ratifying conventions, et cetera, or one of the free citizens, they were electors, they were voting, which is the sort of apex of citizenship, right? Because at the time, for example, women couldn't vote, but that didn't mean that people didn't think they were citizens. And so he goes through his list of five states, as he says, for example, at the time of the ratification of the Articles of Confederation, all free native-born inhabitants of the states of New Hampshire, Massachusetts, New York, New Jersey, and North Carolina, though descended from African slaves, were citizens of those states but had the necessary qualifications. Other historians have gone through and suggested that list is under-inclusive, that, for example, Pennsylvania and Connecticut, at least, probably should also have been in that list. Vermont also is an asterisk because it was sort of a quasi-territory-ish thing, and it had suffrage. Certainly did at the time of when Vermont becomes a state. And there's a more sort of questionable, but some have suggested even in Maryland. So at the very least, even if you exclude Vermont, even if you exclude Maryland, a majority of the states clearly had that. Clearly had basically not only black citizenship, but black suffrage. And it's also worth noting in some of these states still had slavery at the time. It was moving toward gradual emancipation. But strikingly, even North Carolina is on that list. So Curtis basically says, you say the founders could never have envisioned having black citizens, but in fact, a majority of the states did. So just Taney on the merit, like they agree that Taney is using the right method to interpret the Constitution, how this had been sort of popularly understood, but they're hammering him for, I think quite rightly, for just utterly atrocious and tangentious history, which is ignoring like the actual legal arguments. So the case is also just offensive not only to Northerners, not only anti-slavery people, but to like anybody who can like look at history. It's just an offensively bad argument across the board. And that further exacerbates. And the other argument that he gets hammered for is Taney says Congress can't regulate slavery in the territories. And Curtis and McLean say Congress has an enumerated power to set all necessary rules for the territories, which is to say they basically can govern it with the police powers like a state would govern itself. And they say it doesn't say only in the territories we had at the time of 1787 or 1789. It just says Congress shall have power to regulate this in the territories. Taney goes through this really, really convoluted argument to say why that seemingly very obvious reading doesn't apply. And so it's bad enough from the Northern perspective that they're basically having slavery shoved down their throats, but that they're being told that on incredibly dubious history that's torturing the Constitution and constitutional history is sort of another thing entirely. So the opinion is really infuriating to the North. And so unsurprisingly, one of the things that they're very explicit about in the 14th Amendment debates is that it is overturning the Dred Scott case and holding that effectively everyone who was born in the United States, with the little asterisks about jurisdiction and Indians and so on. But other than that, everyone who's born in the United States is a citizen, sort of period. And that's clearly overturning the Dred Scott case. And obviously, the implications about whether Congress can regulate slavery in the territories is taken care of with the 13th Amendment, which not only Congress would continue to regulate that even in the territories without the 13th Amendment, but the 13th Amendment also sort of settles that question. So those two amendments are basically designed to ensure that the Dred Scott case is wiped out. So in terms of obviously it triggers, in some sense, I'm not going to say it triggers the Civil War, but it heightens the tensions in a way that makes the Civil War almost inevitable. But then sort of its effects are minimized by those constitutional amendments. Now, there's a longer case, and I know we're going to do a whole bunch of things on Reconstruction, et cetera, about to what extent those are actually then implemented faithfully. But it does, the Dred Scott case does effectively have its legal implications are more or less completely wiped out within a decade.
Okay, wonderful. Well, again, like you said, we are going to be digging more into this. Dr. Beinberg, thank you so much.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.